I think the legislature should stop adopting exemptions from the APA. What do I mean by that? A fundamental purpose of both the federal and California APAs, the Administrative Procedure Act, is to allow public participation in the federal and state rulemaking processes. And this is where the executive branch of government engages in their quasi legislative activities by adopting rules and regulations to implement the statutes that have been passed by the legislative branch of government. Now, key to allowing public participation is providing notice to the public of the proposed rulemaking and an opportunity for the public to be heard during that rulemaking procedure. However, with any exemption from the formal rulemaking process, that exemption precludes any meaningful public participation in the rulemaking process because notice is lacking, and so is the ability for interested parties to participate in and advocate for or against a proposed regulation or other proposed regulatory changes. So an exemption from the APA by legislation is really contrary to the spirit of the law and the rulemaking process. So unfortunately, legislation in the California legislature that creates exemptions from the APA is becoming more and more prevalent, including in budget trailer bills. According to the Office of Administrative Law, the OAL, this is the state agency that's charged with ensuring compliance with the APA. They explain that the APA requirements are designed to provide the public with a meaningful opportunity to participate in the adoption of regulations or rules that have the force of law by California state agencies, and to ensure the creation of an adequate record for the public, OAL, and for judicial review. All regulations are subject to the APA unless they're expressly exempted by statute, as enacted by the legislature. According to the OAL, the following are common examples of exemptions: local rules, internal management memos, forms, audit guidelines, rate, price, and tariff, legal rulings of tax counsel. Adding to this OAL list is now a lengthy one of statutory exemptions that have been created by the legislature. I really think the legislature should refrain from abrogating public participation and input into the rulemaking process of the executive branch state agencies. So what is warranting these statutory exemptions? I think time sensitivities can't be the justification, because in addition to the regular rulemaking process in California, we also have the emergency rulemaking process under the APA. And in emergency rulemaking, there's substantially shortened time for both public notice as well as the time to submit written comments. Now, these emergency regulations are in effect for 180 days, with two 90-day extensions available, so that the regulatory agency can commence its regular rulemaking on the same topic to allow adequate public participation. Nonetheless, emergency rulemaking even allows for some limited public participation. However, an outright exemption eliminates the need for any public notice or participation. You know, it's one thing if regulations are not necessary based upon a determination made by the regulatory agency itself, but it's entirely different to not even subject rulemaking to the formal public notice and review process. These statutory exemptions also represent an unwarranted delegation of legislative authority that's made by the legislature to the executive branch of government. Instead of ensuring that the legislature remains an equal branch of government, by granting this authority to a regulatory agency to entirely bypass the APA, the legislature, in my view, weakens its position towards the executive branch. When these state agencies engage in quasi-legislative activities, their rulemaking effort should have an appropriate check and balance and ensure that the public, particularly the regulated community that will be subject to these regulations, has the ability to participate adequately and fully in the rulemaking process. I mean, can you imagine the legislative process without public notice of bills and hearings on those bills, and even no opportunity for the public to participate in a legislative hearing on a bill? Seems silly to me, but that's what's going on in the rulemaking process when the legislature grants these statutory exemptions from the state APA.